Thank you for joining us today for a special presentation, Minimize Chaos in a Dynamic Environment. I'm Nathan Wilner, NCBA's Government Affairs Officer, and I'd like to welcome you to today's event sponsored by Oliver. Oliver transforms legal servicing by consolidating data, orchestrating collaboration, and accelerating litigation strategies on a cloud-based platform with unprecedented automation. Their collections litigation platform provides complete oversight of your litigation process with built-in federal, state, local, and venue-specific laws, rules, and procedures, simplifying litigation and increasing revenue with rigorous compliance. Now for a few housekeeping items. This is a pre-recorded webinar, and CLE credit is not being offered. This information is for the use of webinar attendees only. Any distribution, reproduction, copying, or sale of this material or the contents hereof without consent is expressly prohibited. This information is not to be construed as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure that this information is up to date as of the date of publication. It is not intended to be a full and exhaustive explanation of the law in any area. This information is not intended as legal advice and may not be used as legal advice. It should not be used to replace the advice of your own legal counsel. The opinions expressed are the views of the authors alone and should not be attributed to any other individual or entity. Now I'd like to introduce our speakers for today. Nicole Strickler is a shareholder at Messer Strickler and seasoned litigator focusing her practice in the defense of consumer financial services litigation throughout the country. This includes representing clients in both individual and class actions involving state and federal consumer protection laws, including the FDCPA, FCRA, TCPA, as well as similar state laws. Ms. Strickler also successfully represented clients in numerous cases in appeals in various appellate courts, and even as amicus curiae before the United States Supreme Court, is a member of the defense bar and on the board of directors here at the National Creditors Bar Association. Thomas Michael. Thomas is an attorney and legal entrepreneur. He is the founder of Oliver Technology Corporation, a software platform that helps creditors enhance control and increase profitability in legal collections, as well as Logix, a legal services firm that uses technology and quality-driven processes to provide collection litigation on behalf of creditors. Tom has brought his own style of innovation and forward thinking to the collection industry for the last 15 years. He takes pride in working closely with clients to find new solutions and reaching new heights in their strategies. And Walker White. Walker is currently the CEO of Oliver Technology Corporation, an emerging RegTech, LawTech, SaaS business, which stands for Software as a Service, in case you didn't know. Walker is an accomplished CEO with demonstrated success building and growing businesses, organizations, and markets. Having spent over 20 years in broad range of technical, operational, and leadership roles, Walker has developed expertise in organizational development, defining vision and message, and executing against strategic plans. More than anything, Walker's passion is developing exceptional organizational culture and teams that achieve great things. And now I'm pleased to turn it over to our panel, and we're going to be turning it over to Walker. So Walker, the floor is yours. Thank you very much for joining us today.
Great, thank you very much, Nathan, and I appreciate everybody joining today's webinar, specifically to Nicole and Thomas Michael for joining today. I'm looking forward to the what's ahead here today. Today's webinar is the third of a three-part webinar series where we've been touching on what Oliver sees as a paradigm shift in the collections market. Specifically, this move away from a decentralized approach or a decentralized model of the past to a more centralized approach, which is really consumer-centric and creditor-driven, but ultimately really aided by technology. And over the course of this webinar series, we've gotten some great perspectives. Our first session was kind of the creditor perspective during a conversation with US Bank and attorneys from Ballard Spahr. Then our second session was what we called the regulator's perspective, where we spent some time with Andrea Mitchell of Mitchell Sandler, who does a great deal of work with the CFPB and so on, to really look at this changing paradigm through the lens of the regulators. And then finally, today we're going to wrap this up with the perspective of the servicers. That would be the law firms, agencies, whatever it might be. And I use that term broadly here, because I think it's extended now to process servers, potentially appearance counsel, and so on. And arguably, with what may come out of Hunstein, maybe that tent's even bigger, and will include vendors as we move forward. So I'm very fortunate today to be joined by Nicole and Tom, and so I look forward to discussion, and we'll we'll get started right away. Our agenda today is, again, we're going to start by looking at some of the key factors that are driving this paradigm shift. And we'll dig into that a little bit and get some feedback from Tom and Nicole on that. And then specifically, we're going to start looking at comparing the old and the new through the lens of a servicer or a law firm, in the sense of what are the failure points that we're trying to resolve with this move to a new paradigm. And then ultimately, we'll just do a quick summary of, what do we believe the components of really this consumer-centric, creditor-driven model look like in the future. And we're going to have a couple of slides we're going to show as we go through today's meeting, but they're really to serve as guideposts for the conversation we'll have with our two panelists, Nicole and Tom. So we'll go ahead and jump right in, and we'll just start with the driving factors behind the paradigm shift. So from our perspective and what we've been exploring over this webinar series has been kind of three major themes we see in our industry. The first is that regulatory change will continue to be consumer centric. This train really only runs in one direction. In the sense that the rules and procedures that are put forth by the regulatory agencies are only going to make it going to be more and more consumer centric, more and more consumer friendly. The current administration may make that train run a little bit faster, or the previous one maybe a little bit slower, but it is basically proceeding in this path, and that's not going to change. Second thing is that the regulatory resources are going to be focused and remain focused on the creditors. I think a key lesson learned in the 2008 financial crisis was that requiring banks to assume some responsibility for the conduct of their vendors was the single best way for these agencies to stretch their limited regulatory resources and address consumer protection issues of concern. So I think that we believe that this is going to continue, and I think it'll probably be highlighted even more as we move in conjunction with the previous item, which is more and more regulatory change being consumer centric. I think those creditors are going to become under the microscope more and more. And then ultimately, the last point is really about kind of the traditional, if you will, decentralized approach is now, as a result of these previous two, creating risk and new risk in this new environment. And this is where we'd like to kind of start our conversation you can think of this kind of as a summary of the things that we've gone through with the previous two, but from a servicer's perspective, I'd like to get Nicole and Tom to weigh in on these 2 points. So Tom, I'll start with you today. You run a collections firm. You're really at ground zero for a lot of this change. What is your experience on the regulatory changes, and specifically, what is your take on the current decentralized model and how that affects that?
Yeah, thanks, Walker, and Cole, Nathan, everyone. It's great to be with you here today. My career in collections is almost entirely, not completely entirely, but almost entirely been in the shadow of the CFPB. And the pending rules and everybody's reactions to those rules. So really early on in my experience in collection industry, I started to see this, the decentralization and the impact it had on law firms. At the time, earlier in my career, I came from doing court appearances, and I saw the impact of decentralization then, where requirements were coming down from creditors through law firms that were then hiring me and people like me to go to court. And so there was just a natural sort of draw to move towards a more centralized approach, even at the time. And now, as we've seen that train, as you're calling it, continue to move, and we're getting more and more down the road, whether it's through additional rulemaking that we're seeing coming into play, or just the evolution of case law, the requirements, and even not things driven by external forces. Sometimes it's just internal creditor requirements. Whatever the source of the compliance requirement is, the trend towards centralization away from decentralization seems to be apparent. So from my perspective, the decentralized model is actually accentuating the risk that's coming as these things change. So it seems just like a natural progression to move towards centralization.
Right. Nicole, you're in the business of defending firms and agencies and creditors. From your experience, what changes and challenges are you seeing law firms and agencies and so on take in response to these regulatory changes that we've been seeing in the market?
Well, I would say that creditors definitely are more involved than they were 10 years ago. I mean, that's something that I think was a natural progression, as a result of the financial crisis, as you mentioned, Walker. And additionally, just more state laws being implemented that actually make creditors responsible, as opposed to the past where, the main level of concern was as to the Fair Debt Collection Practices Act, which obviously, only applies to debt collectors. And, we saw an increase in state laws that were directed more towards creditors, even at the state level. So I think as a result of both, agency administrative actions and, these developing state laws, creditors have taken a much more responsible, so to speak, approach to, farming out their accounts. And so, as a result, there has to be more process and procedure in place. There has to be more standardization. These large banks are under greater scrutiny, and so their requirements have increased. And as a result, their oversight has increased. And, creditors are very particular about their particular book of business, so to speak. So, and they're different depending upon, what their internal protocol is, what their the way they want to deal with consumers, and what they want to show the outside world too, what their reputation is, so to speak. So, we've definitely seen an increase in the desire to have more control over vendors, and I don't see that changing in the immediate future.
Right. Right. Wonderful. So, okay, well, great. Good. So, again, the premise here is that, these things are occurring. There's a decentralization and the vendors are moving. And I think that leads us kind of to the next point here, which I think we'll spend a little bit more time kind of talking about the aspects of, comparing the old and the new and looking at it from a kind of where have we seen the opportunities or where are there failure points in this process that we can potentially address with this new paradigm and technology. And we think those failure points fall basically into four areas, and they may seem, for those that are operators and so on, these may seem like very kind of technical terms, data and operations, compliance and scale and so on. But I think we're going to unpack these in a much more kind of legible way as we go through here. But I want to talk about them because I think they are kind of the underpinnings that are going to enable this transition to this more centralized, creditor-driven, consumer-centric model as we move forward. So the way we'll do this is basically we'll look at, kind of some of the characteristics of the current failure point, if you will, what we believe is the way to solve that, and then we'll have discussions with Tom and Nicole on the various points as we go through there. So let's get started. So in the old paradigm, we refer to data as the first problem, and that the data is very fractured. Coming from a software background, I can assure you that the kind of very antiquated data formats, data collection, data transfer mechanisms that are used in this industry are really quite limited in their benefit to basically all of the parties. It works, obviously, because we've been able to do this, but I don't think we've seen a great deal of improvement in this area over the past few years. And I think that the benefits are really dramatic. The problem is that this just creates fragmentation, and it makes it difficult for creditors to provide oversight and manage the relationship with the consumers. There's just when this data is spread out, it's very difficult to get a kind of a comprehensive picture of what's going on a file-by-file basis. So, we think that the fix to this is through, this new paradigm where we're going to do really three things much better. The first thing we're doing is consolidation. We're going to bring the data together into, if you will, a litigation master record, make it visible to all the parties. And when I say visible to all the parties, I of course constrained by the accessibility aspects of it. If you have the proper permissions, you don't get to see certain things. We just don't throw it over the fence anymore. The second thing we're doing is really giving you the ability to automate with modern technology and make these tasks that we previously have done manually, much more automated, if you will. The loading, the cleansing, the redaction of data. These are all things that are kind of well served in with various technologies today. And then the last point about accessibility is really with proper permissions, just making sure we're able to share the data and the exact same data with all the interested parties and not having to wait for like overnight file batch loads and so on. This data should be readily available and available to everyone in that supply chain, if you will, or that value chain as it goes through. So that's kind of the technical description of the value here, but I would like to get kind of Nicole and Tom to jump in here and kind of make that real for us all. So Nicole, the question to you is this. I imagine you've seen, and maybe you can give us some actual examples of a lot of cases where a law firm's data or a servicer's data or potentially lack of data was an enormous issue for them, and probably created, probably you had to go to trial on things like that. So I just kind of like to get your experience, kind of looking backwards at, the problem of data and how it has manifested itself, if you will, in the work that you have done.
So I think there's a couple different things I can say about that. For one, it's not only the lack of data, but the interpretation of the data between the creditor and the the third party, either the law firm or the collection agency. So, the creditor may categorize a particular data point as XYZ, and the agency may interpret that data as, ABC. And so that's been something that has occurred, and mostly that occurs in the context of the balance due. And so whether interest is truly interest, whether a credit is a payment, that comes up quite a bit, where it may have been categorized as a credit by the original creditor, but the agency sees it or law firm sees it and they interpret it as a payment. That can affect a lot of different things, such as statute of limitations calculations, or in those states that have substantiation requirements. I'll give you a practical example. New York, in the event that you request substantiation, you got to delineate different things out of the balance, and that can be inaccurately calculated if you don't have the same understanding of the data point that the creditor has. So that's been an issue. The other thing I've seen more often now is allegations that we didn't comply, that the law firm didn't comply with like notice of representation because it went to the creditor, and perhaps like that information never got transferred over to the debt collector, or dispute information that had come up, like what happened with the dispute, what did the creditor ultimately determine, and was that information communicated over to the creditor, or I'm sorry, the law firm. So those are just some practical examples of things that I've seen that have led to litigation, just in practice.
Right. That's fascinating. I think it's just the sharing of information is the representation you brought up there, which is that like, hey, we call it it's tomato, right, between two entities. And I think that in Reg F and obviously the new G notice, you've got the enumeration of all the things that are in there. Like we're going to solve this problem, right? Because like these things are going to go out as they are. So Tom, you sit in the practitioner's chair, day in, day out, as far as consolidating data, what benefits do you see as a practicing firm that this would bring to bear?
Well, first and foremost, having an ability to kind of speak a common language among different clients. If we can get anywhere near that, I think as a servicer, the job that we do would be just significantly enhanced. But even accepting that that creditor data is going to be in the format that it is, that's not likely to really change given the the way that each bank, as Nicole mentioned earlier, manages their inventory and their internal systems and data points and how they handle it all, that they're never going to get onto the same page. So to the extent that we can find tools that help us consolidate information, bring it all into one place in a really consistent way, and that lets us share that information, is just really helpful. We've been able to build a lot of processes around a data set that the data that we have available to us, that I think, in large part is only available to us for the clients that we have working in the Oliver platform. We have clients that are not in the Oliver platform, and that just creates a big hurdle to get over when you're trying to build automation, when you're trying to standardize your process and streamline things without throwing either one-off processes at things or extra bodies at things. So I guess from a practitioner's perspective, having data that is clean, that is consistent, this field always means the same thing, it doesn't matter which client it is just really completely invaluable. Yeah.
Great. So let's we'll move on to the next one, and kind of item number 2 here. And this is again a very kind of tactical issue, but kind of in the old paradigm we had this kind of, again, it's decentralized, so everyone operates on disparate platforms, right? There are a lot of data, a lot of systems involved, files being kind of ping pong back and forth between systems. And matter specific communication often gets relegated to emails or texts or phone calls. So, and then again, this is pretty inefficient given current technologies. Any one of us today, operates with LinkedIn or Facebook. You see the type of capabilities that are available to us for sharing information rapidly, and with folks that we need to share, want and need to share it with. So again, we think the fix to that, and the kind of the new paradigm, is one where we start with collaboration, right? Let's create a single place that holds the litigation master record, again, accessible to all parties at all times, and allowing what we call near real-time interaction, right? Not the batch processes, but like literally being able to get it in near real time. And we're very specific about the terminology near real time. It's not real time like in a rocket launch or something like that. Orchestration, effectively orchestration is about automating the many handoffs, approvals, reviews to just accelerate the process, and really trying to capture a kind of standardized audit of the who, what, when of each of those transfers. And then the last piece of this is that if we operate on shared technology, we really can get end-to-end visibility, and this is particularly valuable, I think, to the creditor. And I think, Nicole, you touched on this earlier, is that like they want standardization, but to be able to compare apples to apples across what's going on in Colorado and what's going on in New York, or what's going on in California, I think is kind of the holy grail for them to be able to say, okay, yeah, our policies and procedures are being followed across this, in addition to obviously the laws, rules, and procedures of the state or locality in which we're doing this. So my question again to our panelists, Nicole, we'll start with you again, kind of looking at the existing system. And again, I'm not expecting you to answer questions about technologies that folks use, but have you seen situations where risk has been increased as a result of lack of collaboration between parties, maybe on specific processes such as client affidavits, contested litigation, and settlements, and this is really just a function of them operating on different and disparate platforms?
I mean, I would say that the biggest problem I see is timing about the information that goes back and forth, that if there's a delay or a scenario where things are not updated quick enough, and so the creditor is not furnished with the information in a manner that allows them to react on their end. Mostly I see this in the context of credit reporting, where generally the creditor is still the one that is credit reporting the debt, whether they're a debt buyer or original creditor, and something happens on the collection end that affects that credit reporting, and there's some sort of delay. And so that definitely causes issues. I mean, collaboration really is very necessary once an account is in litigation. As I know everyone on this webinar that's probably listening to us, knows. And a lot of times, just given the increase in scrutiny by the courts themselves, which they're requiring more information from particularly debt buyers, there needs to be more of a back and forth between those on the creditor end and those on the the litigation end. Whether they need different information, more media, explanation for whatever dispute the debtor has brought up while they're in court, and the delay and the lag in that not only can cause delays in getting the matter resolved, but can also cause irritants with the court and the trial judges who, if they're seeing a pattern of delay or whatnot, there can be a lot of issues that come up with that. They're just you're no longer their favorite litigant, and you don't want to be that person in a small town court in, say, St. Clair County, Illinois. So so yeah, those are all things that I definitely see. So collaboration, visibility, having that real time or close to real time communication really can not only help, I think, increase efficiency of collection, but from a regulatory standpoint is very helpful in being the compliant one.
Right. It's interesting that ironically, the timings that you bring up, it's kind of built into the data processes that we have in this market today, with the batch files on a nightly basis, the update files and so on and so forth. It's just, it's frankly, it's a little arcane in comparison to using, modern technologies and APIs that can keep this stuff up to date on a regular basis. So Tom, I'll come to you on this question of kind of the disparate platforms. You've had the opportunity to actually do this, and I know that historically our market has tried this once or twice in the past, in the sense of like creditors implemented a system and then said to their law firms, yeah, you will operate on this, but you've actually been in this, and so you've seen probably some benefits of working on the same platform as your clients. So can you just kind of share your experience there?
Sure. I think it's worth mentioning that this point, the collaboration or the existing paradigm has people working in disparate platforms, kind of builds on the data point, right? Like we have to start with having the same consistent data, and then we can, ideally be collaborating together, whether it's in the same platform or in a common platform, using data integrations or maybe user interfaces or whatever it might be. So I mean, I think at a really basic level, without trying to overcomplicate things, like it sort of reminds me of this article I read recently. It was talking about how kindergartners get together and solve problems, and it's this case study where they compared how they put a bunch of materials like toothpicks and popsicle sticks and glue and things like that on a desk and gave them to kindergartners and the same list of materials to some MBA students, and consistently the kindergartners are able to build taller structures than the MBA students are. And so I think that this situation that we're in here with in our industry with the creditors, law firms, all of the vendors we have, it sort of reminds me of this, like this example. Like we're just trying to build the best thing we can out of the sticks that we have on our table. And so the more we can work together, the more we can put everything on the table and say, like, this is our data, these are our processes, and then get around that table and work together, the better the outcome is going to be. So when you build walls in between people, whether they're like physical walls like we have in this industry, we're working with people that live and work and sit hundreds and thousands of miles away, in different companies, operating on different computer systems, all that stuff, or intangible walls like psychological walls, or perspectives that we each have, given like, well, I'm the lawyer and they're the client, things like that. When we can really actually collaborate together on whatever the objective is, the outcome is always better. At the end of the day, we're all just people trying to build the best thing we can. So my experience with this, has been, I think, unique to your point, Walker, in that, I was fortunate enough to be there in building out a collaborative litigation program with Oliver and the folks that we've been working with. As an attorney, I've also had other experiences with clients that are not in that environment. So I can kind of get this, A and B comparison. And the collaborative approach just wins every time. Like to Nicole's point about timing, you name it, maybe it's a data point like she's mentioning about credit reporting. Maybe it's something as simple as getting a client to approve a settlement while you're in court. Maybe it's, getting the affidavits back so you can take your defaults quickly, and not have courts sending you more mail about why aren't you taking your defaults in time. All of that stuff weighs down on the operation of a law firm and ultimately on the litigation strategy that a creditor is trying to run. Using those examples of affidavits, like there's enough mail in this business. Like having courts send us extra mail that we have to pay someone to open and scan and decide what does it mean. It's just unnecessary work, and all because of lack of collaboration, lack of orchestration. Orchestration is everything in time, right? Like that's an orchestra. If they all just play their instruments independently, it's just noise, right? So, I don't think it can be, again, overstated, how important collaboration and orchestration is in this process. So it's nice to take a step back sometimes and see that perspective.
Right. Great. And Tom, I'm actually well aware of the study of the kids, of the kindergartners and the MBA students, and it's really actually very dramatic. It's their towers are consistently 40% taller than the MBA students and the reason is they attribute it to kind of the teamwork of it, but specifically the total lack of ego of kindergartners versus MBA students. Who's going to be the leader, and they don't behave like that. They just
in my experience in the client relationships where there is a very collaborative approach, it's exactly that. It's not people like take their hats off and they're like, yeah, everyone knows that you're the client, we're the law firm, and that exists. But when we're trying to solve problems, there's different dynamic that can happen when you're working together, and that client is logging into the same environment as you are, and you're working on the same problem. They see your work, you see their work. And so in a way, some of those things kind of just fall to the wayside because you're just trying to do the best job you can together. So
that's right. That's right. Yeah. And again, it's a lot of this, and Nicole, this touches on the point you made earlier, which is that, reasonable people when presented with the same information tend not to disagree. But if we're all looking at a different set of facts, right, we're not going to agree on things probably. All right. So next point is really around compliance. And, I think keeping up with the federal, state, local, venue-specific laws, rules, and procedures is an absolutely huge cost to everyone involved and a risk, right? The creditors and law firms need to staff to monitor the laws, keep track of them, make sure that, since the formation of the CFPB, kind of the amount of quality control checks and audit requirements has really grown substantially. So, and it's interesting on the second of the series with Andrea Mitchell, she was telling us about how regulators are asking, these very, detailed questions about how companies are keeping track of changing laws across the country. They want to know what their system looks like for keeping everyone compliant. And so you can just see the wheels turning on how are we going to find the opportunities here. So, maintaining compliance requirements is just, it is a costly process, but if we don't do it, obviously we're at enormous risk. So, in the new paradigm, we try to look at this like, to codify compliance. And codify is a technical term, but you can think of it as taking all the laws, rules, and procedures and putting them into a system that can enforce them. And a good example of this that often, if you're not a technical person, is think about TurboTax, right? TurboTax and all these other online services have codified the tax code, so any one of us can go online and by answering a handful of questions can move through the creation of our taxes and ensure that they're done properly. The second thing I think that this really brings to bear in this new paradigm is really the audit process. I don't think there's a question that, for creditors or others that they're going to be audited, but I think pairing that codification with a system that can, automate the auditing. So like every single step and every single handoff and when and how long, whether it's capturing attorney meaningful involvement or, when it was released to be mailed, and then, okay, 5 days after that, it's, we can assume it's been arrived or delivered and so on. That's, I think, very, 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 very critical. And then the third point here is really around customization, which is to say that there is definitely still an art of litigation, right? This is not, the law is not going to be taken over by machines, because there are many ways to, achieving the outcome. And so we want to make sure within inside that framework of codified of compliance, if you will, laws, rules, and procedures, that we have the ability to allow firms to kind of operate and express the art, again, if you will, of compliance. So Nicole, I'm going to ask you a slightly different question on this front, and it's going to be kind of, you obviously, for the NCBA, I'm going to ask you to step into the shoes of the creditor and say, look, as a creditor, from their perspective, as they manage this network of firms that are doing their work for them, what challenges or risks have you seen when compliance is really decentralized to each of these individual firms on a state-by-state basis?
Well, I think that each state is very different in terms of the requirements that are present. Particularly in the information that would be necessarily triggered to be sent to the consumer if certain events were to happen. Obviously, there's different requirements for different states in terms of like the media and documentation that must be available, varying attestations or affidavits that may need to be made by the creditor. And I think, having a centralized system of managing a large batch of inventory, knowing that there are this many changes or variants state by state, can be, very key in, being efficient and compliant. So, I don't know, and I know a lot of, attorneys may only practice in, a couple of states. So, that's kind of their specialty, or that's their wheelhouse. But a lot of the larger creditors or different lenders operate on a national or mostly national basis. So having that information in a centralized portfolio system, I think, for them to be able to monitor, the compliance of the varying vendors, and just getting a handle on, maybe what's more profitable or not profitable for them to be engaged in. I mean, each state is very different. So, I think keeping those lines of communication open to be able to, be the most compliant, but also efficient. I think, a centralized system, I don't know what you would get. It really couldn't be a better option than a decentralized system. Right. Comparing apples and oranges. Why wouldn't you want to compare apples to apples?
Right, absolutely. Tom, again, your firm, Logix Lawyers LLC, you guys operate in 14 states. So this is probably, near and dear to your heart. How does how does compliance on a state-by-state level, how does this help you, basically?
So I was maybe start by kind of thinking through like all the various aspects of compliance. We've got like, okay, client directives, like these are the things that clients want me to do, whether it's an SLA or whatever the case might be. You've got the federal rules and state rules, just the consumer protection rules that we all know and love. And then there's the civil procedure, compliance with civil procedure. So I got to do this in this time and that in that time, and keeping the court happy, as Nicole was describing earlier. So it kind of goes without saying that you kind of relying on a system that can remember all these things is a much better approach than relying on people to remember all these things. So for me, I started out, I mentioned earlier, in my career in collections and watching a lot of other law firms work, and I was never getting sued, but I would see them get sued regularly, and I thought, man, that's gotta not be fun. And when I threw my hat into the ring of being a collection firm, that the risk of that was definitely, over my head. And so the ability to sleep well at night, not being terribly worried that, like, did one of our, clerks do something that they shouldn't have done? Did something go out and it, did not one thing go out without any of the documents attached, but did like hundreds of things go out, hundreds of complaints go out without the appropriate documentation in this state, which requires it, as opposed to that state, which does not. So it's just, my perspective is first and foremost on this point about just peace of mind. Like, I don't have to remember this. I don't have to be ever vigilant on, looking over everybody's shoulder all the time. Like, are you doing this right? And so that's just, from my perspective, a better way of managing compliance is just to bake it in to this.
Not to interrupt you,
Yeah.
but something you said kind of triggered something for me as well. One of the things we forget is that there are defenses to some of the acts that we often get sued on, as in the credit and collection world, and one of those is the bona fide error defense, right? And so policies and procedures, and having those policies and procedures standardized, implemented, and being able to point back to them and show how they were followed in all these scenarios, and yet there still happened to be a mistake here or there, is very helpful from the defense world, in a scenario where a mistake does happen. Because and we all know this, but in reality, everyone makes mistakes, and there's going to be an issue here or there. But being able to point back to that standardization in terms of, like, here's all the things we did to make sure that this didn't happen, and yeah, something happened, but here's what we did to prevent it, is huge in the defense world. And being able to defend a suit that comes across your desk that is that moment of, oh no, right? So I just wanted to add that in.
Yeah, thank you. Walker, before we go into the next slide, I also want to just talk about the auditing portion of this. So much of being a compliant organization is based on your ability to go back and test yourself, or have other people testing you to basically keep you honest. It would be it's not a great world if the only people keeping us honest is the consumer bar, right? Like, we need to keep ourselves honest first, and in each of our firms, and then ideally we have clients that are working together with us in a collaborative way to also keep us honest, and we keep them honest, and everyone's working together. But that basically means auditing. What happened, when did it happen? So going through audits with again, clients who work together in a collaborative environment versus going through audits with clients that don't work in a collaborative environment, two totally different experiences. The ones that are working together, obviously that audit is more, it's just easier, right? They are familiar with what's going on, they see everything. They don't feel like they have to turn over every single rock because they don't know which rock something's hiding behind. They feel like, I can see all of the things. It's all of the cards are, face up, right? And you have to kind of get used to that, I think, approach a little bit, that they can log in and go in and look at any one of these matters at any time and see what's going on. Specifically inside of the Oliver platform, they can go in and see who did what and when it happened with really great detail, which can be sometimes a little scary as an attorney or a law firm, like knowing that someone can see with that level of granularity all the things that are happening and have happened. But once you kind of wrap your head around that, you find that, like, overall it's better, right? Sunshine is good, right? So I think you know, the audit process becomes better in this environment as well. Because in part, you don't have to make sure that the people are keeping everything, you're not just relying on people, right? So you can audit the machine and make sure it's doing its thing, and then shrink the places where people have opportunities to make human error, because they always will. And as long as, you know, we can kind of keep that in the smallest footprint possible within our process, the safer and more compliant it is.
Great. Good. Okay. Well, last topic here, and then we'll summarize. Is really, in the old paradigm, litigation lacks economy of scale, which is to say that the variation in laws, rules, and procedures by state make it really difficult to achieve economies of scale. And I think that the point here is that the processes that we have in place, or the solutions that we have in place, don't allow us to really get great scale out of what we're doing. And as a result, we think that kind of the solution of this is, we've touched on these points before, but seen through a slightly different lens here. You know, standardization. If you think about the kind of the river, if you will, of matters moving, you know, there are tributaries based on, you know, state or county, that the venue that it's going through, but they're all moving down a specific path. And so our attempt to kind of like standardize that as much as possible, still giving the firms obviously the you know, art of litigation capability, is important. We've talked about consolidation many times, but if you think about that from an economy of scale standpoint, you know, having the firms, you know, including the attorneys, the paralegals, the vendors, the creditors, you know, everyone who's involved, be able to access this more quickly. Everything moves faster, right? The cycle times are reduced, and therefore you start to generate scale much more quickly. And then finally, automation, again, we touched on before, is, again, we look at the kind of the overall file management from kind of the cradle to grave of this, you know, we're trying to offload as much as the kind of manual hammer swinging that we have to do, be it processes like affidavits or, you know, creation of documents, whatever it might be, just automating all those things into a process for all the parties involved. So Nicole, again, I'll start with you. Kind of in your experience, have you seen risks arriving from nuances in state and local kind of rules and procedures that have caused firms to implement potentially inefficient processes that kind of to ensure compliance? And really what I'm asking you here is, like, in their attempts to stay compliant, are they constraining because of the technologies that are available to them, in the need for kind of manual intervention, are they constraining what they can do because you just can't hire enough people, basically, and remain compliant with all the rules that are coming through?
Yeah, I mean, I definitely think that's a struggle. I mean, obviously, the more rules and requirements that come down from both the state courts, from like a civil procedure perspective, and additionally, you know, the back and forth communications with consumers when they're required, you know, they're able to demand more information, absolutely, you know, causes a backlog, so to speak, and can be difficult even from a processing standpoint, where they just can't keep up with, you know, the number of communications back and forth. I've actually seen this more, actually, it kind of reminds me of a client of mine that does a lot of email correspondence, and sometimes, you know, their emails back up quite a bit, and the communication back and forth creates quite the backlog, and sometimes that creates a situation where they are not able to timely notate things like disputes or issues with an account, where there's a delay, and that can sometimes cause issues. But yeah, I mean, it's a staffing thing, right? So the more requirements there are, the more documents you have to produce, the more documents you have to review, the more correspondence you have to review. That's more people. So and, you know, sometimes you know, those people, you know, are prone to make mistakes too. So there's a lot of things that come into, I think, the analysis, but one is definitely it increases the number of people that you need to have on the ground, you know, running through things.
Right, and as well-known fact in all industries, like the more work you have people doing, the faster you're pushing them, the more mistakes they end up making. So as you're trying to gain that scale, you're actually potentially putting yourself at more risk you go forward. So Tom, you can wrap us up here today. On kind of you've got direct experience here. How has the implementation of kind of these new capabilities that we've been discussing here, how has it improved the efficacy of your firm? I mean, you've been using it for a while. I mean, what is your direct experience in utilizing this?
My experience has been pretty. It's been foundational to my experience, I think, is probably the words I'm looking for. And that might go without saying, but I'll put it into context. Let's say 5 or 6 years ago, I had a collection practice that was doing small amount of files in one state that grew to 2 states. And then in the course of the last 2.5 years, let's say, I was able, with a new set of technology, a new set of tools, to build a law firm that's now in 2.5 years, approximately, gone from 2 states to 14, with a team of people that really, prior to that time period, had not done this, this kind of litigation management. They had some experience in collections, but not to this degree, for sure. And we're doing that work with I would say a level of efficiency from a staffing perspective that I'm not seeing in other firms. Our ratios, our attorney to staff ratios, are well below 2 staff to 1 attorney. It's probably closer to 1 to 1. And while that may expand somewhat, it's not gonna be by some factor of 2 or 3 or 4 or anything. So the economy of scale that you can get in this practice, I think, is possible with the right combination of tools and systems, and the right approach. You have to kind of design for scale, which litigation, you're always fighting an uphill battle because of the court system, because of the rules, and especially if you're doing it in more than 1 or 2 states. Like, you can definitely find scale if you've got a handful of states that are all quite similar to each other,
right.
Or you stay in 1 or 2 places that those ones well, and you build your systems to just do those ones. But from my experience, the 14 states that we're in couldn't be more different. We have file first states. We have lots of file first states. We have a couple serve first states. We've got Ohio, which is just different than everything. And we've got states that do e-filing and states that still want wedding signatures, and it's the entire gambit of things that are out there. So tackling that problem, if it's a problem you decide to tackle, right? Once you dive in, having the right set of tools to do it makes all the difference. And I think first, it makes a difference to the firm. We're attorneys because, well, there's probably lots of reasons we're attorneys, but if you're running a law firm, you should be doing it to make a living, or provide for yourself and your employees and the people that you're taking care of, and then do the best job you can for clients and help them succeed in their strategies. And so I think bringing an approach that is designed to tackle the economy of scale in this industry is really critical. And the ability to handle the variation in each of those states and maintain scalability is where I think we're kind of out on a new edge, I think, of what's possible in high volume litigation world. We're talking about it in collection, but that would apply, I think, anywhere, this set of tools.
Tom, it just strikes me that by kind of embracing this here for the first time since probably the dawn of electronic file formats, you're changing the unit economics of this for the benefit of a law firm, right? On a file by file basis.
got started doing collections files, like actually not doing appearances, but moving into the collection litigation realm, acquiring a small firm out of central Pennsylvania. And they had been around since the 70s and literally walked into this this system of files. They did have some electronic files, but everything was also in paper, and every single file was in filing cabinets. There were dozens of them, and this was a small practice, dozens and dozens of paper files. And they showed me this box on one of the filing cabinets, and I said, "What is this?" And they said, "That's our tickler system." And I didn't know what that was. I hadn't seen anything like that. It reminded me of like the library cards when you were in elementary school and they had to teach you how to find the Dewey Decimal System or whatever, So it's been an experience to kind of see how this work was managed, in the absence of technology, see it sort of in transition. I said that practice did have an electronic matter management system, but, it had a ton of limitations to it. And they were really working out of paper files. And then to go from that kind of evolving into the environment that we work in today, where the lion's share of the work is being automated, is just, it's been an experience. So.
Right. Wonderful. Well, quickly, just to kind of to summarize, first, Tom and Nicole, really appreciate your time here today. I just want to, kind of summarize what, from Oliver's perspective, what we really believe are the components of this kind of centralized creditor-driven model moving forward. We just believe that there's the ability to create a collections litigation platform that can consolidate and orchestrate all the repetitive regulatory and legal processes. And if you can do that, you can drive more revenue, you can maintain rigorous compliance, and ultimately simplify the litigation process. And we really kind of see that over three kind of primary buckets. We've talked a lot about these, about consolidation, orchestration, and litigation. But on the consolidation side, being a very data-centric solution, right? Let's focus on creating that, if you will, litigation master record, where everyone who's involved with the appropriate security can get access to that information, very accessible. And this is, again, these are modern technologies and modern patterns, if you will, for sharing of information. At the orchestration level, really what we're talking about is establishing that compliance framework, right? The federal, state, local, even venue-specific laws, rules, and procedures, codifying that into a solution that allows us to basically move things through this process very rapidly, yet stay within the boundaries of that, but ensure that collaboration occurs. And then finally, in the litigation process, just ensuring that we have, can maintain end-to-end visibility of the file, like Tom, you mentioned, and I think Nicole, at the very outset, you mentioned that we're heading this direction. Creditors are demanding it. Tom, you've from a lawyer's set, you've been in that seat where they can see down what you're actually doing, but it's basically what they are being forced to from what's coming down from the top end of this, but then still being able to build in those standard operating procedures which are unique to maintain the art of litigation, and standardizing the overall audit process. So we see this as the execution of that new paradigm in these various abilities to kind of centralize the data, automate collaboration, and really accelerate collections as we move forward. So for those of you, again, thank you for joining us here today. I just want to remind everybody that this has been part of a three-part webinar series where we've been exploring this new paradigm. Part one, again, was the creditor's perspective. It's available on demand. You can see the link there at the bottom, olivertechnology.com/webinars. We have the regulator's perspective that we ran. Again, also available at that URL, and then we'll be releasing this one on July 20th, which is probably today if you're watching it today, but will also be available on demand at the same URL. So with that, I will first say thank you to our panelists, Nicole and Tom Michael. We really appreciate your insights and experience here. And I think, Nathan, at this point, I'll hand it back to you to close us out here today.
Well, thank you, Walker, and thank you to Nicole and Thomas for doing such a fantastic job and sharing your expertise with us today. And of course, thank you to Oliver for your sponsorship and sharing this information with our members. This concludes today's webinar event, and we thank you all for your continued support for the National Creditors Bar Association. Thank you and have a good day.
Thank you.
Thanks.